Hi, my name is Carly, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I wanted to talk to you all a little bit about quid pro quo harassment under the California FEMA regulations and how to assert a valid claim. And to establish a claim for quid pro quo harassment, there are several steps that have to be taken. So, we're going to break it down in just a couple minutes. So, before we break down the steps of what's required to bring a valid quid pro quo harassment claim under FEMA regulations in California, I first want to distinguish between quid pro quo harassment and hostile work environment harassment because those are two different things. So, under hostile work environment harassment, the harassment is going to be some kind of unwanted behavior, and it's going to be harassment that is like so severe, continuous, frequent, ongoing, oppressive, abusive, offensive that it creates a hostile work environment. So the harassment has to be so severe, pervasive that it creates a hostile work environment. And the employer has to have alerted about the harassment and then have failed to intervene or adequately intervened. That's hostile work environment harassment. Harassment under quid pro quo at a very top level explanation, that type of harassment occurs only when your job position or an employment decision is based on adherence to the harassment. Does that make sense? Let's go ahead and break it down a little bit further so we can make sure that you all understand the difference between the two different types of harassment. So, in quid pro quo harassment, there are 5 elements that must be met in order to bring a valid claim under the FEMA regulations. So, there's a harasser, there's the harassment itself or unwanted conduct, there's conditional employment, there's got to be some kind of consequence. That's the 4th element. And then the 5th element is that the harassment has to occur during some kind of work activity. So work activity is the 5th element. Okay, let's break that down a little bit further. So the first element, number 1, the first element that you have to prove in order to bring a valid quid pro quo workplace harassment claim under FEMA regulations in California. So the first element is that the harasser has to be someone with authority to make decisions about the victim's or harmed person's employment. Okay, terms of employment. So a supervisor, a manager, something like that, someone with authority. That's the first element. The second element is the harassment itself. There's got to be some kind of harassment. And as we have talked about on this channel before, harassment is really simple. It's just unwanted conduct. It's typically unwanted, repeated, pervasive, severe. It's got to be oppressive, offensive, or maybe even abusive. It's got to create intimidation. In general, it's really just any unwanted conduct. It could be sexual advances, making fun of disabled people. It could be race-based harassment. But in general, harassment is defined as unwanted conduct, requests for favors, again, crass jokes, oppressive, abusive conduct that would make someone feel intimidated. It can be verbal, it can be nonverbal, it can be physical, it could be non-physical. Again, and it could be even an accident or a mistake, just unwanted conduct. The third element is conditional employment. So that means that the harasser has to either promise or condition or threaten to rescind certain job benefits based off of the employees, the person who's being harassed, their response to the harassment. So whether that's being hired or fired or promoted or getting a transfer that you had wanted or a pay grade or a reduction of hours, or maybe you wanted to work on a certain project, but there's got to, or maybe your benefits, your employment benefits are either being, you can either have them or not have them based off of your response to the harassment. It could even be just continuing of employment, like you, in order to keep your job and stay secure in your position, they're not taking anything away necessarily or promising anything different, but just continuing to have secure employment is going to be conditioned upon a person's response to the harassment. So that's what conditional employment means. It means that the harasser is actively either threatening to take away or add benefits, some kind of job and employment benefits to the employee, and that there is some actual consequence that the employee experiences because they did not submit to the harasser's conduct. So we've got the harasser who has to have some kind of authority. We've got the harassment and how we define that. Then we've got some conditional employment, which is a promising or rescinding of job benefits. And now the fourth element that you need to prove in order to bring a valid quid pro quo harassment claim under FEMA is that there has to be some type of tangible consequence. So the third element is that there's conditional of employment, and the fourth element is that there's some kind of negative consequence that the employee experiences because they did not succumb or submit to the harassing conduct. So if you can make that connection and tie the two together and show that the employee did not get the job or was not transferred or didn't get the promotion or was fired because they did not submit to a supervisor's harassment, then you have met the fourth element. The fifth and final element that has to be proved in order to submit a valid workplace quid pro quo harassment claim is that you have to prove context. So the harassment had to have occurred during some kind of work activity, whether that was an on campus, like on location at work in person incident that happened, whether it was a remote situation that happened, whether it was at an event or a social event, pre-work or after work, but it has to just be related to some kind of work activity. Maybe out with all of your friends on a Saturday night and one of your colleagues who is your friend, they hit on you. And then when you get back to work on Monday, it's a little bit awkward. And maybe that person who hit on you is just a colleague. So then we're missing the elements of that person being a supervisor and having any direct position over your job and ability to make decisions about benefits. And then we also have the element missing that the harassment, that potentially asking someone out may or may not, depending on additional context, may actually be harassment. And then the other element we would be missing there is that this happened at a social event on a Friday night with a bunch of friends who coincidentally someone was a colleague, but it didn't happen as a work-related activity. So the fifth element is that the harassment must occur during work activities. So it's when all of these elements align, all five of those elements align, that you may have a successful quid pro quo workplace harassment claim. Understanding and identifying these elements is really important. It's the first step that you can take to better protecting yourself in a workplace. If you live in California, work in California, and you feel like you may have experienced harassment, please feel free to reach out to the Manifest Justice Law Corporation. We'll provide a free consultation and just help you better understand what's going on in your situation, what your rights are, and potentially what your next best steps should be. If you live outside of California and you have questions about a potential harassment situation at your workplace, then I urge you all to reach out to your local bar association. Typically offer free legal referral services, and even the associations that don't offer that service, you can typically call them and tell them what's going on, and they'll at least help point you in the right direction to help find that attorney. Everyone works, but not everyone is safe at work, so you can go ahead and follow us for more tips, tricks, and information about your workplace right. Bye.